the counsel for the DCJ objected to allegations 4 and 5 on grounds that the judgment of the High Court in petition number 23 of 2012 restricted the mandate of the tribunal to the matters submitted in the petition to the President by the Judicial Service Commission. That petition referred to Article 168, Clause 1, Paragraph E, read together with Article 75, Clause 1, Paragraph C of the Constitution. It was pointed out that allegations 4 and 5 were based on Article 73, Clause 1, Paragraph A and Paragraph B of the Constitution. The Tribunal gave a ruling upholding the objection and struck out allegations 4 and 5, but retained allegations 1, 2, and 3, which were couched as follows. Allegation number 1, statement of gross misconduct and misbehavior, that the Honorable Lady Justice Makoha Baraza, while holding the office of the Deputy Chief Justice of the Republic of Kenya and Vice President of the Supreme Court, conducted yourself in a way and a manner demeaning the said office. Particulars of gross misconduct and misbehavior, that on 31st December 2011, the Deputy Chief Justice of the Republic of Kenya and Vice President of the Supreme Court, Honorable Lady Justice Nancy Makoha Baraza, refused to submit herself to be searched by the duly authorized security officer and walked on without being searched at the Village Market, a shopping complex along Limuru Road in Nairobi, in breach of security protocol. The said event triggered a chain of reaction events which allegedly included her intrusive and unwelcome behavior on the person of Mrs. Rebecca Kerubo Ogweche by pinching her nose while indicating to her that she should know important people. Allegation number 2, statement of gross misconduct and misbehavior, that while holding the office of the Deputy Chief Justice of the Republic of Kenya and Vice President of the Supreme Court, you threatened to shoot Mrs. Rebecca Kerubo Ogweche with a pistol. Particulars of gross misconduct and misbehavior, that on 31st December 2011, at the Village Market, a shopping complex along Limuru Road in Nairobi, the Deputy Chief Justice of the Republic of Kenya and Vice President of the Supreme Court threatened to shoot Mrs. Rebecca Kerubo Ogweche with a pistol. Allegation number 3, statement of gross misconduct and misbehavior, that while holding the office of the Deputy Chief Justice of the Republic of Kenya and Vice President of the Supreme Court, you created disturbance in a manner likely to cause breach of the peace. Evidence. It is common ground that at about 6:30 p.m. on 31st December 2011, the DCJ entered the Village Market shopping complex through the Nakumat entrance and bypassed the security desk without undergoing screening. There are two versions of what transpired after that. One is that narrated by Rebecca Kerubo and Anthony Mahano, while the second version is as related by the DCJ and her driver, Eric Omond. The first version. Kerubo testified that on the material day, she was screening female customers, and next to her was Mahano, who was screening male customers. She saw the DCJ passing the security desk on the side that male customers were being screened. Customers in the queue started grumbling about discrimination. Kerubo called out to the DCJ and told her that she wanted to screen her handbag. The DCJ, however, continued to walk away rapidly and entered Belladonna Pharmacy. Kerubo followed the DCJ and stopped at the entrance of the pharmacy. The DCJ, who had entered the pharmacy, came out and Kerubo told her, quote, "Excuse me, madam, "Madam, I have to check your bag." End of quote. The DCJ, who was very harsh, responded by pinching Kerubo's nose and told her, quote, "You should know people." End of quote. The DCJ re-entered the pharmacy and beckoned Kerubo to follow her. Kerubo did, expecting that DCJ to identify herself. Instead, the DCJ informed Kerubo that she was an important government official and Kerubo should know people. Kerubo told the DCJ that she too should respect her work. The DCJ then placed a hand on Kerubo's shoulder after telling her, quote, "Don't call me your sister. I am not your sister." End of quotation. Kerubo then resumed her duties at the security desk. A short while later, the same DCJ reappeared at the desk. The DCJ told Omondi, who was standing nearby, quote, "I want you to shoot this lady now." End of quotation. Omondi did not respond, but he asked Kerubo to keep quiet. Kerubo continued with her work when suddenly the DCJ appeared and pointed a pistol at her and said, quote, "I want to kill you now. If you want, I can kill you now." End of quotation. Kerubo begged for mercy, and people standing nearby asked the DCJ to cool down. Kerubo ran away from the scene and went into the village market security office and reported the matter to the security manager, Jared Obonyo Meshak. He asked her to go home and return the following day. On the 1st January 2012, Kerubo reported the matter at the Gigiri police station. Kerubo recorded her statement, and she spoke on telephone to the DCJ, who had been called by Hassan Bwengo. The officer commanding the station, Kerubo recorded her statement, and she spoke on telephone to the DCJ, who had been called by Hassan Bwengo, the officer commanding the station. The DCJ came to the station and met Kerubo, and they talked. Kerubo told the DCJ that she would first wish to talk to her husband about any reconciliation. On the 2nd of January 2012, Kerubo went with her husband, Bernard Morara, to the Gigiri police station and met with the DCJ, who was angry and said that she was unhappy with what she had heard in the news and that the case could go to court. The DCJ further said that she was a judge and the government would assist her. Thereafter, they parted ways without reconciliation. Earlier, on the 1st January 2012, Kerubo had gone to the village market security control room and was shown a CCTV clip of the previous evening's events by John Makori. Kerubo said she distinctly saw the DCJ's hand pinching her nose. When she next viewed the clip on 6th January 2012 in the presence of police officers, she was shocked that it no longer showed her nose being pinched. Kerubo did not tell this to the police officers present as he was in shock, but she later informed Mahano. She reiterated to the tribunal that the DCJ pinched her nose and pointed a pistol at her. Kerubo said that she planned to report the pinching or the nose pinching after she completed her work. Upon further examination, Kerubo said that when she was threatened with a pistol, she immediately went to make a report to the village market security officer. She testified that she subsequently met the DCJ at the DCJ's request in February 2012 and on 27th June 2012. During the second meeting, the DCJ tried to get Kerubo to change her testimony to say that she did not see a pistol, but instead heard the words, quote, "bunduki, bunduki," end of quotation. In his testimony before the tribunal, Mahano, who was screening male customers at the security desk, said he saw the DCJ pass by the side the male customers were being screened. He then had Kerubo called out to the DCJ that she needed to be screened, but the DCJ did not stop. Mahanu said that Kerubo followed the DCJ, and near the entrance of the pharmacy, Mahanu saw the DCJ turn back and pinch Kerubo's nose, saying, quote, "Stupid lady, you should know people. Why are you shouting at me?" End of quotation. The DCJ then entered the pharmacy. Kerubo followed her into the pharmacy, but came out soon thereafter when Mahanu called her to return to the security desk. A short while later, the DCJ came to the security desk and asked Kerubo, quote, "Why are you shouting at me? I am a senior person. Why are you shouting at me?" End of quotation. Kerubo tried to explain that she did not know her and that she was under instructions to search everyone who wished to enter the shopping mall. As they were talking, the DCJ said to Omondi, who was nearby, quote, "Bodyguard, I want you to shoot this lady right now." End of quotation. Omondi did not take any action. Kerubo apologized and explained to the DCJ that she did not let her know who she was before passing the screening desk. The DCJ said, quote, "Give me a minute." End of quote. She left and a short while later returned holding a pistol, which she pointed at Kerubo and said, quote, "I have come to shoot this lady." End of quote. Kerubo begged for mercy and told the DCJ that she was sorry. A man who was standing nearby, told the DCJ, quote, "Madam, what you are doing is wrong." End of quote. And the DCJ cooled down and left. Mahanu had rang the control room, but by the time the supervisor arrived, the DCJ had left. In his testimony, Mahanu stated that Kerubo did not use any abusive words against the DCJ. Mahanu further testified that on 26 June 2012, the DCJ rang him and told him that she wanted to meet him and Kerubo. Mahanu contacted Kerubo and they met with the DCJ on 27 June 2012 at Gigiri Shopping Center. They went into a restaurant but left after the DCJ got concerned that a worker called Faith had recognized Kerubo and Mahanu. The three of them then entered the DCJ's official car, which the DCJ drove to Karura Forest parking area. The DCJ told Kerubo that she wanted them to forgive one another and said that, quote, "To err is human." End of quotation. She gave Mahanu 2,000 Kenyan shillings and Kerubo 5,000 Kenyan shillings for their fare. Mahanu further explained that if a customer refuses to be screened, that the guards on duty are required to ask such a person to identify him or herself and ask the reason for refusing to be screened. If the person is still adamant, the guards can call superiors. On the material day, the supervisors came about 20 minutes after Mahanu first called. He further said that he first called the control room after the DCJ passed the security desk, and the second time he called the control room after her return from the pharmacy. In his testimony to the tribunal, Mahanu clarified his statement to the Judicial Service Commission that his words to Kerubo, quote, "We will deal with her," end of quote, meant that on the DCJ's return from the pharmacy, they would ask the DCJ to identify herself and explain why she had pinched Kerubo's nose. Mahanu, in his testimony, said that he did not remember screening anyone carrying a pistol on the 31st December 2011. The second version of the story. The DCJ in her testimony before the tribunal said that on 31st December 2011, she went to Limuru to see her son who was sick. She spent that afternoon with him. She was driven there by Omondi. Her son was distraught because of the fact that he might not get the opportunity to go back to school. It was a disturbing visit. She said that her son required some medication. She therefore decided to drive to the village market to buy the medicine. She arrived at the village market at about 6 p.m. She wanted to get the medication before the pharmacy closed and planned to have the medicine delivered to him the same evening. She was in a hurry and inadvertently passed the security desk without submitting her bag for screening and continued to walk. She noticed people standing in a queue at the security desk. Someone called after her saying in Kiswahili, quote, "Wewe mama, unapita bila kuangaliwa, wewe mjinga namna gani?" End of quotation. The DCJ looked back and saw Kerubo was addressing her. She continued walking and entered the pharmacy. Kerubo followed her in. The DCJ tried to explain to Kerubo why she had not stopped, but Kerubo was angry and her eyes were red and she would not listen to her. Kerubo said, quote, "I do not care who you are. Everybody is to be checked." End of quotation. The DCJ tried to calm Kerubo down by touching her shoulder and covering Kerubo's mouth with her hand whilst identifying herself. A shop attendant in the pharmacy intervened and the DCJ walked away to the counter. She did not see Kerubo after that. The DCJ purchased the medicine and she left the pharmacy. She met Omondi along the corridor. Omondi took her handbag and they walked towards the car. On her way out, she saw Omondi talking to Mahanu at the security desk. In her testimony before the tribunal, the DCJ denied that she pinched Kerubo's nose, or that she asked Omondi to shoot Kerubo, or that she threatened her with a pistol. The DCJ further denied that she went to the car and got a pistol, as she did not know where the car was parked, and in any event did not possess or is licensed to carry a pistol. Omondi was armed, but he did not take his pistol. She further stated that on her appointment as DCJ, she had received a security briefing from the police. Her strict instructions were never to step out of her car without her security. She had, however, gone to several places without the VIP escort or bodyguard, Annalise Kaburu. She stated that the reason for not always having Kaburu with her was that Kaburu lived at the Central Police Station lines, while DCJ lived in Gigiri. The DCJ said she found it inconvenient to call Kaburu if the DCJ wanted to go to the supermarket at the village market. The DCJ further said that she had driven herself to the village market on 23rd and 25th of December 2011 without a bodyguard. The DCJ had given Kaburu leave from 23rd December 2011 onwards and had not asked for a substitute or replacement. She testified that she had shopped at the village market for many years and had always submitted herself for screening, except when she had Kaburu, who would go ahead of her and clear the way. The DCJ further stated in her testimony before the tribunal that on the 1st January 2012, she received a call from Bwego, who told her that a complaint had been lodged against her to the effect that she had threatened Kerubo with a pistol. She spoke to Kerubo over the phone and met her later that day at the police station. She said that they spoke about reconciling, and Kerubo said that she would first speak to her husband. On the 2nd January 2012, the DCJ said that she went back to the police station and met with Kerubo and Morara. He spoke and asked for 10 million Kenyan shillings as compensation in the event that his wife lost her job. The DCJ said that she refused to consider a financial payout for reconciliation or forgiveness. The DCJ self-recorded her statement with the police at her house on 3rd January 2012. She stated that the next day a journalist called her and has asked her about the incident, which was carried by news media for many days thereafter. The DCJ further stated that in the first week of February 2012, she met Kerubo after Omondi and one David Onyapidi told her that Kerubo wanted to reconcile. At the meeting, Kerubo's lawyer asked for Kenya shillings 10 million to withdraw the case and reconcile. The lawyer told the DCJ that she did not know what she was fighting and that she was up against. The DCJ said that after she refused to pay any money, the lawyer scaled down his demand to 4 million Kenyan shillings, which proposition she rebuffed. The lawyer called her several times thereafter, but that the DCJ put him off. The DCJ further denied before the tribunal that she offered Kerubo shillings 3,500,000 Kenyan shillings in order to settle the matter. The DCJ further confirmed that she called Mahanu to arrange a meeting between her and Kerubo. On 27th June 2012, she met with Kerubo and Mahanu. They met in DCJ's cars at Karura Forest. The DCJ said that Kerubo told her that if she got some money, she would withdraw her complaint. The DCJ did not agree to the proposal to pay the money, and they parted. The DCJ then gave Kerubo 5,000 Kenyan shillings and Mahanu 2,000 Kenyan shillings after they had asked her for the fare. The DCJ stated that this was not an inducement for them to change their evidence. The DCJ said that Kerubo had told her that she feared for her life, and the DCJ wrote to the Chief Justice on 8th February 2012 to provide Kerubo with security. The DCJ further stated that she was apprehensive that if any harm befell Kerubo, she would be blamed. The Chief Justice wrote to the Commissioner of Police to provide Kerubo with security and copied the letter to the DCJ. The DCJ denied that she ever sent emissaries to Kerubo's house, but that she was aware that several people, including her friends, had tried to intervene to assist her. Omondi told the tribunal that on the evening of 31st December 2011, he dropped the DCJ off at the Nakumat entrance of the village market. He parked the car and walked back to the same entrance. The DCJ had not told him where she was going. He was screened at the security check, where he showed his police identification card and informed Mahanu that he had a pistol. As he stood at the security desk, he heard a scuffle and shouting. From where he stood, he could see inside the pharmacy and all that was going on inside. He heard Kerubo tell the DCJ, quote, "Wewe mama mjinga unajiona sana," end of quote. The DCJ did not respond to the words. He also said that he saw Kerubo grabbing the DCJ's bag. And on further questioning, Omondi said he was not alarmed by this, as he noticed that it was a security guard pulling the handbag, and so he did not intervene. When the DCJ reached Omondi's position, he took possession of her bag. Kerubo remained in the pharmacy. Then on his way out, Omondi spoke to Mahanu and told him that they should not have embarrassed the DCJ. Omondi then accompanied the DCJ to the car and they drove off. He denied that he gave his pistol to the DCJ. He also denied seeing the DCJ brandishing a pistol at Kerubo. Omondi further stated that sometime in March 2012, he met Onyapidi, a co-parent at their children's school. Onyapidi told Omondi that Kerubo, who was his colleague at work, wished to reconcile with the DCJ. Omondi organized a meeting between the DCJ, Kerubo, and her husband Morara. Omondi went to Kerubo's house at Gachie to collect them. He took them to a restaurant at Gigiri where they met the DCJ and later went with them to the DCJ's house. Omondi told us he did not know what they discussed, but they evidently did not reconcile. Omondi stated that his duties were to protect the official car and to perform his work as a driver, but did not include the protection of the person he was driving. He said he was not supposed to be a bodyguard and had not received any training for that role. On the material day, he followed the DCJ into the village market with the intention of carrying her bags. Independent witnesses. Benedict Ichingwe Muhani worked at the pharmacy. On the evening of 31st December 2011, he saw a security guard enter the pharmacy. She was arguing with another lady that he did not know. He moved closer to hear what they were saying. He could not hear what they were saying. A colleague of his told the guard she was out of order in coming into the pharmacy and she left. The customer who he identified as the DCJ remained in the shop and was served. Muhani did not hear any of the words the DCJ uttered. The talk between the two had not been friendly. Dr. James Wathigo was a pharmacist at Belladonna Pharmacy. He testified that at about 6 p.m. on 31st December 2011, after he had served his last client for the day, he heard unusual noises from outside the pharmacy. He then saw two ladies coming. One was dressed in a security guard's uniform. He recognized the other as the DCJ, who was their customer. He heard the DCJ tell the guard that they were not sisters. The guard told the DCJ that she needed to be searched. The DCJ looked annoyed at the treatment she was receiving from the guard. The DCJ responded that she was the DCJ and that the guard, quote, should know people around here, end of quote. The DCJ then walked to the counter. A short while later, she beckoned the guard and asked her to apologize. The guard apologized in low tones and left the pharmacy. At some point, Wathigo asked his colleague to call the village market security to deal with the problem. The DCJ completed her transaction and then left. 15 to 20 minutes later, Wathigo went to the Nakumat entrance where he found a security man and a multitude of people. He also saw the security guard who had been earlier in the pharmacy, leaving while carrying a handbag and a paper bag. Other witnesses. Among the other witnesses, the largest group is of police officers of various ranks. These conducted investigations of the incident, and their evidence is largely what they were told by the three principal witnesses, that is Kerubo, Mahano, and the DCJ. These were 8, but 2 of them were attached to the DCJ as a driver and a bodyguard. We shall deal with them separately. The remaining 6 were Police Constable Daniel Kioko, who was the desk officer on duty at Gigiri Police Station on 1st January 2012, and so received Kerubo and recorded the matter in the occurrence book. He told Kerubo to report to Bwego, who passed on the investigation to Superintendent of Police Peter Mungai, the Divisional Criminal Investigation Officer, Gigiri. Mungai was of the opinion that Kerubo and Mahano concocted the story to save their skin after they realized who the DCJ was. He recommended that the duo be charged. The case was taken over from Mungai by Senior Assistant Commissioner of Police Peter Mwao Muinde and Senior Assistant Commissioner of Police Mohammed Amin. The other officer in charge, the officer in charge of investigation branch at the CID headquarters. The 2 officers irregularly recorded the confession of the DCJ, which the tribunal refused to admit in evidence. Then there was Mr. Maxwell Kibene Kiplimo, who had been in charge of the CID cybercrime unit of the Kenya Police. He investigated the CCTV system of the village market and found out that the cameras which would have taken pictures of the security desk supervised by Kerubo and Mahano were not working, and so there could not be pictures of the pistol incident. There is nothing much in the evidence of these officers apart from what they have said above, or we are going to point out later, or on regarding any officer. They have largely repeated what they were told by Kerubo, Mahano, and the DCJ. Balsio Ngota was supervisor at the village market. On the evening of 31st December 2011, he received a radio call message from the control room asking him to proceed to the Nakumat entrance where there had been an incident. He started off immediately and arrived there after 5 to 10 minutes. He found a crowd of between 10 to 15 people. He went to his guard, Mahano. Kerubo was not present. Mahano told him what he told the tribunal as to what had transpired. Kerubo returned, and she too told Ngota what had transpired, and she started crying, and so he asked her to go to the control room, where the security manager, Mr. Obonyo, sent her home. Ngota watched the CCTV on the 1st January 2012, and so the DCJ raised her right hand towards Kerubo. Jared Obonyo Meshak is the chief security officer manager of the village market. On 31st December 2011, at about 6:30 p.m., he heard over his radio handset that an incident had occurred at the Nakumat corridor and that a supervisor was required on the spot. A supervisor is usually asked for by the guards on fixed assignments whenever an incident occurs which they feel they cannot handle. Meshak did not go to the scene as he had other engagements. 20 minutes later, at about 7 p.m., he went to the control room and found Kerubo, who told him what had happened. He saw that Kerubo was distressed and allowed her to go home to rest. He watched the CCTV clip of the incident and saw that, quote, there was a stretch of the hand towards the guard and it pointed around the shoulders, end of quotation. He stated that the camera that covered the security desk was off at the time of the incident, and therefore there was no video evidence of a pistol incident. On 1st January 2012, he permitted Kerubo to go and make a report to the police. He said Kerubo should not have left her post to follow the lady, and that this was a security lapse. He produced the job cards confirming that the CCTV cameras had been taken for a repair on the material day. He, however, stated that at the village market they did not do body search and they did not touch people, but rather they only checked bags and passed a scanner over their bodies. John Onyango Makori, a surveillance controller at the village market, on 31st December 2012, he was watching the CCTV and receiving calls. He received a telephone call from Mahano, who said there was a problem at Belladonna corridor. He viewed the video from the camera and he witnessed an argument between a lady and a guard, but he did not know who the lady was. He called his superior to visit the scene. After a short time, Mahano rang him again and informed him that the incident still continued. It was only the next day, when the police visited the control room, that he realized the magnitude of the incident. He took the tribunal through the CCTV footage and described each event in the clip. As the tribunal watched the clip, the evidence of Omondi was interposed. Omondi denied being the man with the white shirt who took the DCJ's bag and whom Makori had identified as the DCJ's bodyguard. On further examination by the tribunal, Makori denied that he organized for a viewing of the CCTV clip by Kerubo on 1st January 2012. He stated further that the schedule he prepared of the CCTV footage showed that Kerubo left the pharmacy at 18 hours 29 minutes and 52 seconds, about 3 minutes after the DCJ exited. He stood by his notes, but confirmed that he did not receive any input from eyewitnesses. Morara testified that on 31st December 2011, at around 7 p.m., he was in the sitting room of his house with their children. Kerubo arrived. Typical of her, she would greet them all, proceed to the bathroom, and thereafter sit with Morara until bedtime, when they would go to bed together. On this day, she went straight to bed. He followed her and asked her if she was feeling unwell. Kerubo asked him to let her sleep, and she would speak to him in the morning. On 1st January 2011, Kerubo told him what happened the previous evening at the village market. Morora accompanied Kerubo to Gigiri police station on 2nd January 2012, where the DCJ arrived. The DCJ was angry and nothing positive came out of the discussion. Later, several people came to their home seeking forgiveness for the DCJ. In late January 2012 or early February 2012, he met the DCJ at her house, and Kerubo told him that the DCJ was the DCJ had offered her 3,500,000 Kenyan shillings to drop the complaint and go to live elsewhere. He denied ever asking for money as a condition for Kerubo forgiving the DCJ. He also testified that the DCJ did not offer him any money to settle the matter. Police Constable Annalise Kaburu is the DCJ's bodyguard. On 23 December 2011, the DCJ allowed the witness 3 days off to attend to personal business in Meru. She returned to Nairobi on 26 December 2011 and rang the DCJ on 27 December 2011 to inform her that she was back and available. She was not with the DCJ on 31st December 2011. The DCJ did not communicate with her on that day. She was in her house all day and had her firearm in her possession. Kaburu reported back on duty on 3rd January 2012. She stated that in her absence, the driver can accompany the DCJ, in which case he acts as driver and bodyguard. Legality of search. Mr. Kilukumi, in his closing address, submitted that the security check in the village market was unlawful, as it breached the provisions of the Constitution. He referred to Article 31, Paragraph A of the Constitution, which states, quote, "Every person has the right to privacy, which includes the right not to have A, their person, home, or property searched." He also cited Article 58, Clause 6, which states that, quote, "Any legislation enacted in consequences of a declaration of a state of emergency. 1, the limitation is strictly required by the emergency, and 2, legislation is consistent with the Republic's obligation under international law applicable to a state of emergency, and B, shall not take effect until it is published in the Gazette." He also referred to Article 24, Clause 1, that set limitations on the right of fundamental right freedom contained in the Bill of Rights. Lastly, he referred to Section 26, subsection 1, paragraph C of the Criminal Procedure Code, which gave the police certain powers to stop, search, and detain a person. Relying on these sections, it was his submission that the right to search either person or the property offended Article 31, paragraph A and paragraph B of the Constitution. And as such, they were unlawful, and that there was no legislation limiting the right to privacy as anticipated by Article 24. That being the case, Kerubo and Mahanu had no right in law to stop people at the security desk and search them before allowing them to enter the village market. Such a proposition has wide-ranging implication, and it would require a court of law to adjudicate on such a proposition. In this tribunal, we are only concerned with the matters relating to the alleged conduct of the DCJ, and even if the security guard had no power to stop and search the DCJ, it would, if the allegations are sustained, to be no answer to such conduct. In our view, however, that no one has a right to enter any premises without the consent of the owner, and if a condition for such entry is a mandatory search of a person, then the person has the option of either acquiescing in such a search or not entering the premises. Standard of proof and matters to be considered. Ms. Valeria Onyango, the tribunal lead counsel, and Mr. Kioko Kilukumi, counsel of the DCJ, were in agreement that the standard of proof is neither that of a criminal law, that is beyond reasonable doubt, nor that in civil case, which is one on a balance of probability. They instead urged us to adopt the standard set out in the Tanzanian decision, the Judicial Tribunal of Inquiry, in respect of Justice C.J. Mtenga and Mr. Justice M.L. Mwakibete, as well as the Kenyan case, the matter number 3 of 2003, the tribunal to investigate the conduct of the Honorable Mr. Justice Daniel K.S. Aganyanya, which would be somewhat different, which would be somewhere between beyond reasonable doubt and a balance of probability. Mr. Kilukumi added that one would have to achieve a score of 8 out of 10 to consider a fact proved. We agree with the standard of proof referred to in the cases quoted above, but take note of the fact that in order to prove gross misconduct or misbehavior, we must confirm that the allegations have been proved to our satisfaction, and that we have no doubt in our minds that what is alleged to have occurred did in fact occur. However, it is our decided view that since the case of the Honorable Mr. Justice Daniel Aganyanya was decided under the previous constitution, whose relevant provisions are significantly different from those in the current one, there are other aspects which must be taken into account when considering the standards of proof to be observed by this tribunal. Provisions of the Constitution. While under Section 62, subsection 3 of the former Constitution, a judge could be removed for misbehavior, under the current one, Article 168, Clause 1, Paragraph E, the judge must have committed, quote, gross misconduct or misbehavior, end of quote. Where gross suggests that the conduct was glaring, flagrant, or very bad. Additionally, while a tribunal to investigate a twin judge under the former Constitution comprised 5 people, all of whom had legal training and had gained experience in either as judges or were senior counsel, the Constitution of Kenya 2010 provides in Article 168, Clause 5, Paragraph B, for a tribunal with 7 members, 5 of whom are required to have legal training, while the other 2 are selected from among, quote, persons with experience in public affairs, end of quotation. It is evident that the determination of the allegation against a judge of the Superior Court is no longer solely a legal process of sifting through the evidence and finding whether the facts proved support the charge. Now, apart from looking at whether a judge has breached his ethical responsibilities, one has to determine whether the judge has also committed an infraction of other provisions of the Constitution of Kenya relative to the Bill of Rights, national values and principles, as well as those of the leadership and integrity. Hence, the inclusion of 2 persons with experience in public affairs in the membership of the tribunal. National values and principles of governance. Article 10, Clause 1 of the Constitution, 2010, refers to the national values and principles of governance binding on all persons with regard to A, application or interpretation of the Constitution, B, enactment, application or interpretation of any law, C, making or implementation of any policy. In the same Article 10, the national values include Clause 2B, Clause 2, Paragraph B, human dignity, equity, human rights, non-discrimination, and protection of the marginalized. Clause 2, Paragraph C, good governance, integrity, transparency, and accountability. Article 73 specifies that authority assigned to a state officer, A, is a public trust to be exercised in a manner that B, vests in the state officer the responsibility to serve the people rather than to rule them. The same Article 73 defines the guiding principles of leadership and integrity, including Clause 2, Paragraph C, selfless service based solely on the public interest, demonstrated by 1, honesty in the execution of public duties, 2, the declaration of any personal interest that may conflict with public duties, and Paragraph E, discipline and commitment in service of the people. The preamble to the Judicial Service Code of Conduct and Ethics, based on Section 5, Subsection 1 of the Public Officers Ethics of the Public Officer Ethics Act Number 4 of 2003, provides that, we quote, the code is intended to establish standards of ethical conduct of judicial officers to be applied consistently with constitutional requirements, statutes, court rules, and legal authorities, and in the context of all relevant circumstances. It should always be remembered that each judicial officer occupies a special and revered position which must be protected both in public and in private life, so as not to bring the judicial service generally into disrepute. It is imperative, therefore, that every judicial officer should adhere to this code with scrupulous care. A judicial calling is one of sacrifice and restricted lifestyle, a lifestyle which is automatically accepted on appointment to the bench, end of quotation. The following rules in the Judicial Service Code of Conduct are relevant for this tribunal. Rule 3, Paragraph 5. In all activities, a judicial officer shall exhibit respect for the rule of law, comply with the law, avoid impropriety and the appearance of impropriety, and act in a manner that promotes public confidence in the integrity and impartiality of the judicial service. Rule 12, Sub-Rule 1, a judicial officer or any other officer in the judicial service shall ensure that his official and private conduct upholds at all times the dignity and the integrity of the judicial service by conducting himself both officially and in private in a dignified, honest, and impeccable manner. Rule 22, where an officer has committed a breach of this code, appropriate action will be taken in accordance with the provisions of the Public Officer Ethics Act 2003, Judicial Service Commission regulations, or the Constitution, as the case may be. Article 28 of the Constitution, 2010, stipulates, quote, every person has inherent dignity and the right to have that dignity respected and protected. End of quotation. With regard to rules of evidence in tribunals, the Judicial Service Act number 1 of 2011, second schedule, clause 13, specifies that, quote, the tribunal shall not be bound by strict rules of evidence, but shall be guided by the rules of natural justice and relevancy. End of quotation. Justice Ojwang, currently a judge of the Supreme Court of Kenya, while serving as judge of the High Court, made the following observation in Luka Kitumbi and 8 others versus Commissioner of Mines and Geology and another. That is Mombasa High Court case number 100, civil case number 190 of 2010. We quote, I take judicial notice that the Constitution of Kenya 2010 is a unique governance charter, quite a departure from the two, 1963 and 1969, earlier constitutions of the post-independence period. Whereas the earlier constitutions were essentially programmed documents for regulating governance arrangements in a manner encapsulating the dominant political theme of centralized, that is presidential authority, the new constitution not only departs from that scheme, but also lays a foundation for values and principles that must imbue public decision-making, and especially the adjudication of disputes by the judiciary. It will not be possible, I think, for the judiciary to determine causes such as the instant one without beginning from the pillars erected by the Constitution of Kenya 2011. The emphasis is ours. All these references indicate that while determining the culpability of a judge, a superior court, all these references indicate that while determining the culpability of a judge of a superior court, a tribunal appointed is expected to take into account a wide range of considerations while applying a broad interpretation of, quote, national values and principles of governance binding on all persons, end of quote, which constitutes Kenya's national ethos. From the perspective of social justice, there are basic ethical values presupposed and implied in the interpretation and application of Articles 10, 28, 73, and 168 of the Constitution of the Republic of Kenya 2010. Thus, the evaluation of conduct of the holders of public office at all levels extend beyond the provisions and limits of legislation. It includes and presupposes the social domain, whose expectations are taken for granted within society, though not expressed in written law. We have set out in the Schedule 1 a list of the national values is illustrative Kenya, but it is not exhaustive. Thus, the standard of proof applied by this tribunal has to take into consideration this broad range of ethical values in addition to ascertainment of truth pertaining to the allegation on record. Evaluation of the evidence. It is now for the tribunal to evaluate the evidence taking into account the standard of proof we have set for ourselves. To a very large extent, what is in issue is the credibility of witnesses. As we have already pointed out, there are two versions of what transpired on that fateful day, that of Kerubo on the one hand, and that of DCJ on the other hand. Admittedly, the DCJ conceded a great deal of what took place that evening. She admitted to have gone to the village market, to have bypassed the security desk, and to have been followed by Kerubo, who demanded that the DCJ's handbag be searched. There is no doubt that there was an altercation between the DCJ and Kerubo. The DCJ said that all that she was doing was to stop Kerubo from shouting. From the CCTV, it is clear that the DCJ's arm was outstretched outside the pharmacy, whereas according to her, this incident took place inside the pharmacy. This would corroborate Kerubo's story that her nose was pinched. There is also the evidence of Wathigo and that of his assistant, Muhani, who both worked at the pharmacy. The controversy is on whether the DCJ pinched the nose of Kerubo, as the latter claimed, or that there was no such a thing as the DCJ maintains. Kerubo testified that the DCJ pinched her nose outside the pharmacy, and when she followed her into the pharmacy, the DCJ placed her hand on her shoulder. Indeed, the DCJ testified that she did place her hand on her shoulder inside the pharmacy and also placed her hand over Kerubo's mouth to stop her from shouting. The DCJ made no mention of the touching of Kerubo outside the pharmacy. Kerubo had stated in her evidence that on 2nd January 2012, when she first viewed the CCTV footage, it was clear that her nose was pinched. However, on the other occasions, the CCTV footage merely showed the DCJ's hand being stretched towards her. When the tribunal viewed the CCTV, we observed that the DCJ turned around between the security desk and the pharmacy, and then turned to proceed into the pharmacy. She came out, and Kerubo could be seen standing outside and looking into the pharmacy. The image then showed DCJ with her arms outstretched towards Kerubo, and then turning and going back to the pharmacy. Kerubo suggested that the films have been tampered with. However, that was never established. But it is our considered opinion that that is not absolutely necessary for our determination in these investigations. From that CCTV evidence at our disposal, showing the DCJ stretching her arm towards Kerubo, the question for us to determine is, why was the arm stretched? For Kerubo, the arm was stretched to pinch her nose. As for the DCJ, she merely confirmed that it was her stretching, she merely confirmed that it was her stretching her hand, but she provided no explanation. Kerubo's account of the incident was corroborated by Mahano. We have seen both witnesses, Kerubo and the DCJ, giving their evidence. We found Kerubo to be credible from the way she confidently and steadfastly gave her evidence, and especially in cross-examination. In fact, she has been consistent in her statements since 31st December 2011. What she did not know, she forthrightly admitted her lack of knowledge. She never contradicted herself. Kerubo's evidence was corroborated in material particulars by the clear and consistent evidence of Mahano, who remained unshaken even under cross-examination. On the other hand, we were not thus impressed by the evidence given by the DCJ. There were discrepancies in her evidence. For instance, she testified that after she entered the Belladonna pharmacy, Kerubo followed her and used disrespectful language. This was denied by Kerubo. Wathigo, who was in the pharmacy, testified that Kerubo told the DCJ that she needed to be searched. The DCJ responded that Kerubo, quote, should know people around here, end of quote, and walked away to the counter, and from there directed Kerubo to apologize her. The DCJ further informed the tribunal that she was without her bodyguard, Kaburu, because he had given her leave of absence to attend to family matters in Meru. But Kaburu stated that she came back on 26 December 2011 and that she phoned the DCJ the following day. So there was no reason for the DCJ to be without her bodyguard, without her bodyguard on the 31st December 2011. The other matter is whether this DCJ brandished a pistol at Kerubo, threatening to kill her. The cameras which would have captured what was happening at that point of entry and point of exit of the DCJ were said not to be working. That was the evidence of Makori, who works in the control room, Meshach, the chief security officer of the village market, and Kiplimo, who was working with the CID in cybercrime unit. So the only evidence was that of the DCJ against that of Kerubo and Mahano. We have already found that Kerubo was a credible witness, but it may not be out of place to show why she should be believed in this issue too. Her nose was pinched outside the Belladonna pharmacy, and yet she went back to her security desk to proceed with her duties. We ask ourselves, what then made her scared to the marrow and caused her to go home prematurely and then straight to bed until the following morning, as narrated by her husband, Morora? Certainly, it was not the pinching of the nose. Equally, it was not the realization that the lady she was confronting was a VIP, because the DCJ herself told her inside the pharmacy who she was. The only plausible explanation is what she said, that the DCJ brandished a pistol and threatened to shoot her. It is significant that Kerubo only referred to the pistol incident in the report captured in the occurrence book at Gigiri police station. It appeared to the tribunal that had there been no pistol incident, no report would have been made to the police, as despite having her nose pinched, Kerubo went back and carried on with her duties. The DCJ's evidence is that as she does not possess a pistol, and that she has no license to carry one, therefore she could not possibly have threatened Kerubo with a pistol. The DCJ's driver, Omondi, and her bodyguard, Kaburu, both carry a pistol in their assignment with the DCJ, and both stated that the pistols were in their possessions throughout. We find Obondi to be an unabashed liar. He claimed that he went into the village market on that fateful day with a pistol on his body, and that he had to show his police identity card to Mahano. The latter denied there having been any person who passed through the security desk with a pistol on that day. We believe Mahano on this issue for the simple reason that this is an occurrence which one would never have forgotten. Besides, in his earlier statement before the Judicial Service Commission, Omondi said that he entered the village market without being checked. He also contradicted the DCJ in that he claimed he saw Kerubo pulling the handbag from the DCJ, while the DCJ said no one touched her bag. As for Kaburu, We take her testimony with a pinch of salt. Going only for 4 days is not being on duty, entitling her to take home her personal weapon. It may be because she was on a French leave. That is why she did not return the pistol to the armory. We are satisfied that it is not necessary to establish how the DCJ came across a pistol if we believe that she actually had one. Here we must observe that the investigators, if they had pulled their weight, could have produced independent witnesses to prove or disprove that assertion of brandishing a pistol. There were 2 independent guards close to the security desk. One was Peter, guarding the Diamond Trust Bank, according to Mungai, and the other KICC security in the parking lot. Had this been a criminal matter, we would require proof beyond reasonable doubt. But the proof required in this matter is below, quote, beyond reasonable doubt, end of quote, but above, quote, balance of probability, end of quote. And we find that it has been met. We are satisfied that the allegations have been proved and that we have no doubt in our mind that what was alleged to have occurred did in fact occur. Findings. We therefore find that allegation number 1 has been sufficiently proved that the DCJ pinched the nose of Kerubo, and that conduct displayed by the DCJ was demeaning her office, to say the least. Allegation number 2 has also been sufficiently proved that the DCJ threatened to shoot Kerubo with a pistol, and that conduct constitutes gross misconduct on her part. Allegation number 3 has automatically been proved after the proof of the first and the second allegations that the DCJ created disturbance in a manner likely to cause a breach of the peace, which constitutes gross misconduct and misbehavior. Mitigating and aggravating considerations. In determining whether, taken together, all the facts and circumstances already found as established would entitle this tribunal to make a recommendation to the President on whether to retain or remove the Deputy Chief Justice from office, we also have to consider whether there are mitigating or aggravating circumstances. Ms. Gusera, the lead counsel for the DCJ, led her client, who gave a narration of her brilliant career. We have taken that into account. The DCJ has made an outstanding contribution to this nation. She has had an illustrious career as an advocate of the High Court of Kenya. She also served as a commissioner with the Constitution of Kenya Review Commission. In that capacity, she chaired the committee which drafted Chapter 4 of the Constitution, that is, the Bill of Rights. Immediately before she was appointed DCJ, she served as the vice chairperson of the Kenya Law Reform Commission, as well as the chairperson of the Media Complaints Commission. The number of acts alleged gross misconduct or misbehavior is relevant in assessing the suitability of a judge to hold office. An isolated incident may be evidence of the fact that the act complained about was an aberration, a lapse from the normal, and which is unlikely to occur. On the other hand, a pattern of conduct might show that the judge lacks judicial temperament and the ability to perform judicial functions in the manner anticipated by the Constitution and the Judicial Service Code of Conduct. In this inquiry, we are dealing with a single incident. In determining the proper in determining the proper sanction, this tribunal also has to consider the impact of the DCJ's conduct on the judiciary. It must be remembered that every single judge has the potential of preserving or tarnishing the integrity of the judiciary on every occasion. On 27th June 2012, about 1 week before the tribunal was scheduled to start its hearing, and after the DCJ had been served with a list of witnesses as well as witness statements, she contacted Kerubo and Mahano. The DCJ's testimony was that she wished to reconcile with Kerubo, while Kerubo stated that she asked them to change their evidence and to remove references that she, the DCJ that is, brandished a pistol and threatened to shoot Kerubo. This was a very serious undertaking conducted by a judicial officer. We are therefore not convinced that the Deputy Chief Justice can be expected not to engage in this kind of misconduct or misbehavior in the future. Even if she does not engage in similar misconduct in the future, we are not convinced that she would not engage in other types of misconduct. Her failure to consider the effect of her misconduct on her staff and the reputation of the judiciary at the time of her actions leaves us with little confidence in her ability to refrain from future misconduct, demeaning to the esteem of the judiciary. The fact that she improperly contacted witnesses in the absence of the lead counsel to the tribunal also raises concerns about her ability to refrain from future misconduct. She has shown an inability to control her behavior, demonstrating the strong likelihood she will continue to commit misconduct or misbehavior in the future. The DCJ has raised the issue of her state of mind on the evening of 31st December 2011. She stated that she was distressed after visiting her son, who is in a rehabilitation center and whose condition and state of mind are worrisome. A doctor was to be produced to substantiate that submission. However, as the doctor would have taken a lot of time to appear before the tribunal, he was discarded by the DCJ. We are prepared to take the word of the DCJ on this score and to accept that such a situation is very disturbing. We comment that the DCJ mishandled the whole incident. Otherwise, it would not have been as it has turned out to be. Let us assume that her state of mind was disturbed, as aforesaid. When Kerubo trailed her to the pharmacy and demanding to search her handbag, she should have let her to do so. Her story that Kerubo called her discourteously finds no purchase with us, as Wathigo, who is an independent witness, told the tribunal that she heard the DCJ telling Kerubo who she was and that she should be respected. And also that the DCJ told Kerubo that they were not sisters. This clearly indicated that Kerubo addressed the DCJ as my sister. And that is far from being discourteous. Otherwise, all judges are discourteous to one another. Then, even assuming that she was provoked by the way she was addressed and handled with disrespect, which we refuse to have been the case. After the altercation, there was enough time to cool down. But what did she do? She went away, came back with a pistol, and brandished it at the unfortunate woman who was just performing her duty. Surely the second highest or judicial officer ought to have done better than that. In our opinion, a judge who engages in lawless conduct and thereafter tries to explain it away with misleading testimony should not continue in office. Conclusion. Having determined the facts of the allegation facing the DCJ and having found all that we have displayed above, we have concluded that the DCJ committed gross misconduct and misbehavior. The actions of the DCJ were not done in connection with her office duties, but rather with her private life. Rule 12 of the Judicial Service Code of Conduct and Ethics states as follows, we quote, "A judicial officer and any other officer in the judicial service shall ensure that his official and private conduct upholds at all times the dignity and integrity of the judicial service by conducting himself both officially and in private in a dignified, honest, and impeccable manner. End of quotation. The Tribunal is satisfied that the conduct of the DCJ breached the provisions of Article 168, Clause 1, Paragraph E, read together with Article 75, Clause 1, Paragraph C of the Constitution, 2010, and of the Judicial Code of Conduct, and was of such serious nature to amount to gross misconduct and misbehavior. Recommendation. The Tribunal members, having unanimously found that the conduct of the DCJ on 31st December 2011 at the Village Market, Nairobi, amounted to both gross misconduct and misbehavior, we therefore recommend to Your Excellency Mwai Kibaki, Commander of the Order of the Golden Heart,